Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No. Your Honor, would the court accept a no contest plea?
I don't know if the deal was continued upon him pleading guilty, but obviously we have two very, very different.
Right away, notice what's happening here. This case hinges on one crucial detail, where the child was struck. In criminal law, those details can mean the difference between discipline and a criminal conviction. And trust me, courts don't gloss over that.
Versions of what happened.
All right, court calls case, People versus Sean Carlson.
Mr. Plug Senator John, if you leave on behalf of Mr. Carlson, for my right.
Today is the date set for a couple of cost companies. We have reached a plea agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse, 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement.
That is correct, Your Honor. Awesome.
John Matthew Carlson.
Has he signed an advice of rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
Attorney without a pen.
Your Honor, that has been a frequent occurrence for me, unfortunately. Thank you.
You know, that's why they made pockets. You can solve that.
Absolutely.
Man. Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony.
This is important. By pleading guilty, the defendant is waiving his right to trial, appeal, and even to challenge the evidence later. That's not just paperwork, that's permanent. Would you take a plea deal this early if you thought the facts were being misrepresented?
What you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse, 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Mr. Reiser?
I don't believe so. 1 year or probation or up to
5 years, no maximum.
1 year
All right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. And you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan.
Listen carefully to that admission. A closed fist. A 10-year-old. Even when someone admits guilt, the degree of harm and intent still matters. And that's exactly why this case is about to hit a wall.
Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline, and that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just.
And here's the problem: two versions of the same event can't both be true. Courts require a clear factual basis for any plea. If the record doesn't match the police report, the judge can't just look the other.
Just reading, make sure that this is correct for the record. The police report: Sean approached the minor child and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No.
Your Honor, would the court accept a no contest plea?
I don't know if the deal was contingent upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Do this. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up. Let's see what we can do.
Thank you, Your Honor.
Thank you. And then recall the case, People versus Sean Carlson.
Sir, again, on behalf of the people, you know.
Assistant Public Defender Downplay Lee on behalf of Mr. Carlson, who stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson as well as the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have? Oh,
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department, 24-7818, and marked that.
This is why the plea shifts to no contest. It's not an admission of guilt, but it allows the court to sentence anyway. Defendants often choose this route when they are worried about civil lawsuits or conflicting
Injuries to the child and the relationship and the statement from the report, and ask that be admitted on the basis of.
any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7818 of the Ann Arbor Police Department. Sir, the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
Okay. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
View of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, the people are said.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Perry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
It's just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
So that is correct.
Yes, Your Honor.
He's not going to be seeking delayed or deferred.
Sure.
You understand that, sir?
Yes, sir.
Thank you.
Is he's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
And so what's the status currently?
The child is residing with Mr. Carlson.
That last comment from the judge is devastating and deliberate. When a defendant minimizes harm involving a child, credibility collapses. So here's the real question. Did justice protect the child, or just move the case along?
Under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintained some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And protective services thought it was still okay for him to be with me.
And, I've got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face and coming before a court and telling me that. So you're lucky to be leaving today.
Fair enough.
You may leave.
Thank you.
Mr. Peeler, to my knowledge, is not here today. Judge, this is a matter that had been adjourned over from December 26th.
Right, on the next available date, and they didn't pay the second service. Would you like to take a default?
I would like to take a default. Thank you.
Raise your right hand to be sworn. Do you solemnly swear a firm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. Thank you.
Go ahead, sir.
Your Honor, the defendant is currently in arrears to the plaintiff $6,100 in past due rent. Further, we have court costs of $205. We are requesting a default judgment of $6,305.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days.
Thank you, Your Honor. For purposes of some housekeeping, can I submit 3 proposed judgments? I don't have the triplicate form.
3.
Well, just for signature. If I just have one, is that?
I'm only going to sign one.
Perfect.
But if you sign one, we can make a copy for you.
Great. Thank you.
Okay. All right.
Thank you.
Thank you.
Sabrina Jackson.
All right. And where are we in this case?
Yes, this is a subsequent hearing on a non-payment of rent. We do show that currently there is $5,413 in past due rent, as well as court costs of $239.40 for a total due owing of $5,652.40.
And how are we going to get this paid?
Okay, so I'm looking for just a little bit of extension of time. I was able to pay January's rent in full. I was just furloughed from my job December 1st. I am currently working as a substitute teacher for Ann Arbor Public Schools, and we just got back from the 2-week Christmas break, so I wasn't being paid at that time. But I'm just asking for more time to resolve it into moving forward because I still want to stay current with February's rent as well.
Okay. Have you called the attorney's office to try to work that through?
No, sir, I have not.
What?
I wasn't familiar if I could do it. I didn't know if I was allowed to talk with them when it was still in court proceedings.
I got you. I got you. So you paid You said January rent? How
Yes.
much did you pay?
1,600.
Do you have that payment?
I do show that payment, Your Honor, yes.
Okay, that's why effectively the number didn't go up from December to January.
Correct, Your Honor.
Is right, okay, got it. When's the next time you're able to make a payment?
With me being.
I know we don't pay our teachers a darn thing, so I get it, but
It has been difficult. So I just was furloughed from Spirit Airlines. I'm gonna get my vacation check on the 15th from the year for 2025 because I accumulated that vacation time. So I'm hoping to put an additional 600 with addition to February's rent and work down that balance moving forward if that was any way possible. But
So-
completely done by the end of February.
so everything would be, okay. All right, so here's what you're gonna need to do. I'm not gonna do that at this point. I'm gonna adjourn this out a couple weeks. I need you to call the plaintiff's attorney's office.
Okay.
Explain what your plan is, let them run it by their client to see if that can all work out.
So don't go directly to the leasing office, reach out to.
Well, you can reach out to the leasing office, but you're probably gonna have to run it through counsel,
Okay.
all right?
Okay.
At some point, but that kind of process, okay?
Mhm.
And explain to them what you want to do. What you want to do sounds reasonable to me.
Okay.
Certainly. Maybe it's just because I like teachers. But I don't know.
We appreciate it.
What school?
So I work for a staffing agency called EduStaff. So mostly I go to Carpenter Elementary a lot.
Right across the street here.
I love Carpenter. Mr.
Yes,
Johnson's great. The
it's
students
cool.
are great. Oh yeah, I love it there. And I do some Ypsilanti public schools as well because it's through a teaching agency. They just don't pay me as much, but I'm trying my best here.
Okay, well, I'm not gonna say anything about Ipsy Public School.
I love Ypsi as a city. As you can see, it's where I live. I love it so much. I just
Yeah.
moved out this way in 2024. That's why I'm really not familiar with what I should be doing at this
It
point.
is. All right, so, and what grades do you teach?
Well, I go K through 12, but my sweet spot is 4th and 5th grade. That's when they really realize who they are as a person, and we can
Yeah,
really
but then
bounce
that's where
ideas.
you just gotta smack them down.
No
I'm
way.
not kidding. I'm kidding. So it'll be the 23rd, 2026 at 1 p.m.
23rd at 1 p.m. on.
1 p.m. But make those, touch base with your leasing office, touch base with counsel's office
Got it.
with what your plan is to get yourself caught back up by February.
I appreciate that so much.
All
Thank
right,
you, Anna.
Take care.
Bye.
What's your name?
Sade Payne.
Okay. And how much is owing now?
Yes, I do show that there is currently a past due balance of $4,883 with court costs of $239.40 for a total due and owing of $5,122.40.
All right, so you made those payments and basically kept yourself level from December. It
Yes.
looks like. All right, how are you gonna get this paid off?
So I do have an appointment with Hawk on the 12th of this month, and then I'm also supposed to be meeting with Peace Neighborhood as well.
Okay, so you're meeting with Hawk and Peace.
Mhm.
When is the meeting with Peace?
They wanted to see what if I reached out to DHS. I did reach out to DHS, so I need to contact Peace Neighborhood Monday and let them know what's going on with that.
Okay, so here's the way I'm looking at this. When I look at this, there's 5122 that's owed.
Mhm.
For a SOS and Hawk to help you out, you're gonna have to come up with 212240.
Okay.
And I'm trying to figure out where would that happen for you?
Well, I am currently working. So just as I made the payments before, I'm
Right.
working on it and I'm supposed to be starting a new job. So that's what I'm waiting for.
So you're trying to pay that down. So I guess the only way this would possibly work is if Peace Neighborhood Center covers the gap, whatever it is between what you owe and the 3. And then SOS covers you.
Well, Peace is, I thought that was SOS. So I'm,
No.
okay.
So hold on a second. Are you meeting with Hawk or?
Yeah, so Hawk, I have an appointment with them on the 12th.
Right, okay.
Uh-huh.
That's Hawk and SOS. That's basically gonna be the same thing.
Okay.
Peace is a different
Separate.
organization.
Right. So that's why with Hawk, they said they'll cover up to the 3,000.
Right.
And so that's why with Peace Neighborhood, I spoke with them about the difference.
Okay, that's what I was wondering. So and that's kind of, we were saying the same thing. You're looking for Peace to cover that in between, plus you have payments and other things.
Yes.
Okay, let me ask you this so we can see if we can work this out. And this would probably be over the objection of plaintiff, but I'm gonna do what I gotta do. How much can you pay between, say, now and the 23rd?
I'm not sure yet because honestly, I have I'm starting orientation for a new job on the 23rd, and I was off work for a week and a half because I fell and hurt myself.
On your current job?
Yes.
Okay, all right. Well, something's gonna need to be paid to the landlord if I'm gonna try to give this additional time for you to work that out between Peace and SOS.
Okay.
So how much do you think you can get paid to the landlord?
Between now and
Say the 22nd.
I know I could do at least 400.
At least 400. Basically, that's one check because you don't know what the other one's gonna be.
Yes.
Okay. I'm gonna take that because that's gonna put you around that 48 figure, which, knowing what Peace has done in the past, might actually work.
Okay.
They might be able to cover that and then get the other one. All right. So over the objection plan, I'm gonna adjourn it to the 23rd, 2026 at 1 p.m.
Is it possible for 3? Because I have, oh no.
I do it by counsel. So
Okay.
counsel here, she only wants to see me once a day, and that's too much. So, all right. So, I want you to pay that 400 by the 22nd.
Okay.
Okay. You've talked with Hawk already?
Mm-hmm.
Okay.
That's who I have an appointment with. And this was the same as last time as well, because the last time I spoke with you, they didn't have any appointments until the 12th. So
Until the 12th. Okay. All right. So you got Hawk on the 12th. Or did. And then you got Peace Neighborhood Center, and you're calling them on Monday.
Yeah.
Okay. Very good. Okay. Thank you.
Thank you.
If I may,
Yes, I'm sorry.
if she does get those commitment letters, there's a good chance it won't be paid in full by the 23rd, but if she's able to get the commitment letters and provide those to the property, we may be able to submit a dismissal or conditional dismissal in that regard.
Yeah.
So we would just speak to property management if at all possible. You didn't even give me a chance to object, Your Honor.
I know. I gave it for you because I know how it was.
You did. But we would just speak to the property manager for that.
You got that?
Yeah.
You understand that? So if you get a commitment, if there are letters of commitment, get that to them. I think the one that's going to be real important to try to get is the one from Peace Neighborhood Center, because if they make that commitment, Hawk will follow through with the 3.
Okay.
Okay.
Okay. Thank you.
Thank you.
Hey, Mr.
Hello. What's your name?
Mary Blackman. You know me as Mary Gregory.
Okay. This is your motion to set aside the default. And okay, so you're saying you didn't get notice of this.
Right. And naturally, when it first began, they all came late. But
What all came late?
all the notices that I got, I didn't even realize I had to go to court.
Okay. All right. So let me ask you this. The judgment amount in December was taken for 1687.22, I think it is. Okay.
Mm-hmm.
All right.
So
are you saying you don't owe that money, or
not the full amount?
Okay.
I am on RIP management. My portion amount needed to be paid off that, and the water bill was connected to that. That's why I was like, I don't know what this is. What's going on?
Your
Okay,
Honor,
I got you.
I believe she has counsel, Ms. Henry, that's shaking her head right there.
Pardon?
I believe she has counsel, Ms. Henry.
Yes.
Okay, go ahead.
And there is a commitment letter in this regard as well.
Is there did you file an appearance? That's okay. Go ahead, Miss Henry. What were you gonna tell me?
We've spoken to Ms. Blackman several times in regards to the balance and explain that the housing payment is completely separate from the utility bill or the utility charges.
Okay.
But I have a letter.
Oh, hold on. All right. And so the 16, so
I just asked, so
I need you to state your name for the record.
yes, Madden Housing Bureau for Seniors. And yes,
Okay.
the commitment letter is for the up to January. So she'd be up to January. I did not include the $75 late fee that has now incurred. I'm wondering if they would be able to waive that, please.
The 75, when did the late fee go into place?
After the 5th, it goes into place.
After the 5th, when did the commitment letter get?
Just this morning.
Just this morning? What do you guys want to do about the late fee?
Your Honor,
Otherwise, I'm gonna make the call.
We're not waiving the late fee.
and Your
Really?
Honor, we
So
wouldn't.
here's what I'm gonna do. I'm gonna set aside the judgment, send you through a trial. I'll reissue the judgment. It might be $75 short.
Okay.
I mean, she's a senior. Let's just get it paid, folks. Tell you what. Find $37.50. Somewhere.
For me.
Find
Yeah, we got some
$37.50.
here.
I'm just gonna split that late fee.
Okay.
I'm not gonna sit up here and go round and round about it. So account will be deducted $37.50. You pay the $37.50. They're gonna pay the money. She'll be zeroed out basically, and then she can keep moving on from there.
Thank you.
All right?
Because you do have my payment here, don't you? Escrow.
So when is that going to come in, the commitment?
The
Does it say
commitment is in and the check will be early next week.
early
I
next
could have had it
week?
today. I'm just too busy.
All right, so that we don't lose track of this, I'm just gonna put this on the 23rd, and hopefully you got the check by then, and then we can just get rid of this. 2026 at 1 p.m.
Your Honor, may I say something?
Yes, ma'am.
All the notices from there are late. I didn't.
Well, that may not be there. Are you talking the court notices?
No, yeah, there's two that's attached to what they give us.
Are they sending them by mail?
I'm not for sure.
Okay, I will say this. I don't think your landlord nor the court is in charge of the United States Postal Service.
Okay.
All right, and so I realize there are delays in there.
Okay.
Okay? All right.
All right.
Thank you.
I ain't got to come back to it.
You don't want to come back and see me?
No.
That's my.
All right.
2004, Judge Simpson.
You may have to come back on the 23rd, but hopefully everything will get paid by then.
Okay. Nice to see you.
Good seeing
You
you.
remember who I am?
Pardon?
You remember who I am?
I do. I remember a lot of people.
It's been 21 years.
21.
Yeah. Thank you.
All right. Lakestone Apartments versus Katrina Harris.
Attorney Samantha Springfeet, when everyone appearing on behalf of the plaintiff.